Swayam Prabha. Digital India. Educated India.
Hello everyone, this is Dr. Shabnam Mehlawat from the Faculty of Law, University of Delhi. This is my lecture number 9. Previously I had talked about the first law which was drafted in India after the forest laws which were given to us by the British. The first Indian law with respect to environmental matters was the Water Act. After this came the Air Prevention and Control of Pollution Act 1981. So, it was in 1981 that this law was brought into force with respect to air and its related problems. During the 80s, India had started industrialization. Prior to that, it was an agrarian economy, as also stated by me previously. The water law brought with it a regulation which would prevent the wholesomeness of water, not cause and create pollution, and punish the offender in case if he creates or has already created pollution to an extent which cannot be rectified. So, today I will be talking about the Air Prevention and Control of Pollution Act 1981. This law, as we have seen under other laws, it is placed under the union list. We have 3 lists, as also previously stated by me: the union list, the state list and the concurrent list. Under the union list, whatever the list speaks of, it is the central government which has the power to regulate, to form policies or to draft laws with respect to that list. So, this law, which was basically a law created under the aegis of the Stockholm Declaration, it was when decisions were taken internationally. India also became a signatory and party to those conventions, to those declarations, or to any of the activities which were taken up internationally. Now, the air related problems internationally, we have seen there are 2 in number, mainly the Vienna Convention on Depletion of the Ozone Layer, the Convention on Climate Change under the Rio Declaration, and likewise several other associated problems with air pollution have been acknowledged across the world as well as by the domestic laws within our country. Over a period of time, this law remains as the main law under which the central government has the power to make rules and regulations in case a specific problem comes up, and in case it is related to a state area, the state also might regulate. So, the air pollution story resides with the central government, where it may frame laws, where in fact this law was drafted and then it went on to make several rules and regulations with respect to those several problems which have been witnessed and faced internationally. Like we have the ozone depletion rules which were drafted in the year 2000. We have the noise pollution rules, we have the firecracker rules, and we have the rules relating to sound systems wherever they may be installed. These sound systems may be whether it is a firecracker, whether it is a horn in your vehicle, whether it is noise being created around the silent zones which are hospitals and schools, and in other areas of residence only a small amount of noise is allowed to remain. Whereas ozone containing rules and other rules and regulations which are under the Air Act been drafted by the government are followed according to what is banned under those rules. So, looking and reflecting on the Air Pollution Act 1981, let us see the history of this law, where it says decisions were taken at the United Nations Conference on the Human Environment held in Stockholm in June 1972, in which India participated to take appropriate steps for the preservation of natural resources of the earth, which among other things include the preservation of the quality of air and control of air pollution. The 26 principles which were drafted under the aegis of the Stockholm Conference have been accepted worldwide, and India too has participated in the conference and accepted that as a part of the domestic law of our country. In relation to that, the Air Prevention and Control of Pollution Act of 1981 was drafted and brought into force, or it is in short known as the Air Act, and it was a law which was passed by the Parliament of India to prevent and control the harmful effects of air pollution in India. This act was seen as the first concrete step taken by Government of India to combat air pollution. This act initially was a state act, and it was later amended and converted into a central law. So, the objectives of the act are that the Air Act is enacted with the following objectives. It was passed primarily to prevent and control air pollution. To achieve this objective, the Act provides for establishment of the central and the state pollution control boards. It confers such boards such powers which are necessary not only for its functioning, but also looking into activities which create air pollution. They also are empowered and equipped to aid and advise the governments, as well as create programs which might create awareness with respect to the air pollution story. All matters related to the air may be dealt by the pollution control boards appropriately, whether it is the central board or whether it is the state board. Some of the definitions which are considered under the Act are, now what is air? Air is basically the life which we breathe inside while inhaling or exhaling as a living being. So, this air, when it gets polluted or it is poisonous or has certain chemicals or certain external elements which do not allow people to live or breathe freely, then that air is said to be contaminated. The contamination may be caused by an element or a pollutant or a chemical which is injected into the air by a business activity, an industrial activity, or any other activity which converts the fresh or the pure air into a contaminated one. So, to deal with the air pollution controls and problems and the stories and the cases which go to the court for trial, like the famous Bhopal disaster, where air pollution wiped out a large number of population within a few hours. Looking at the definition part of the Act is, under section 2A of the Act, it defines air pollutant as any solid, liquid or gaseous substance which may cause harm or damage to the environment, the human beings, plants, animals, or any living or non-living persons or even property. A 1987 amendment to the Act added noise to the list of harmful substances. So, air pollutant means that some non-natural thing has been injected into the air which a person or which a living being breathes in, and if that is contaminated by external chemicals or any external substance, the air is said to be polluted, and the chemical which is responsible for it is said to be the air pollutant. Section 2B of the Act defines air pollution as the presence of any dangerous pollutant that makes the air unbreathable. So, this definition is taken up in a wholesome way and applied wherever there may be smoke, there may be fire, there may be noxious fumes, there may be other ways which contaminates the air which is not natural or which is contaminated because of human activities. Under section 2G of the Act, a definition of the Central Pollution Control Board is given out, where the powers are extended to the whole of India of this board, which may be enacted to deal with the air problems. So, to carry out the directives of the CPCB, as it is commonly called, it is calls for the setting up of the state pollution control boards, or the SPCB for the individual states of India. The composition of the boards: the Central Pollution Board Control Board is constituted under Section 3 of the Water Act and is authorized to exercise the powers and perform those functions which prevent and control air pollution. Similarly, the State Pollution Control Boards are constituted under Section 4 of the Water Act, where the members are authorized to exercise the powers and perform functions for the prevention and control of air pollution. The composition of the central board goes on to show, like under the Water Act, this board also has a chairman, a full-time chairman, who has the necessary knowledge, a certain number of officials who may be official, who may be non-official, and they may be nominated by the central government from various sectors to represent the central government, the state governments, and certain other officials who may be having an interest in agriculture, fishery, industry, or trade, or any other interest, which in the opinion of the central government ought to be represented by the companies or corporations owned, controlled, or managed by the central government. The functions of the board: under Section 16 of the Act, the main functions of the central board are that it shall go on to perform or improve the equality of air and to prevent, control, or abate air pollution in the country. In particular, and without prejudice to the generality of the foregoing functions, the central board may aid and advise the central government on air and air pollution related issues. It may provide technical assistance and guidance to the state board. It can coordinate the activities of the state board and resolve disputes among them. It may carry out and sponsor investigations and research related to problems of the air pollution. So, in this manner, air and water laws are similar to each other, where it calls for setting up of the boards, performing certain functions, carrying out certain activities, and in cases of pollution, wherever they may be created, whether it is water or whether it is air, it may lead to these boards performing appropriate functions within their respective territories. If it is the central board, they would be responsible for any air pollution story in the entire territory of India. But if it is a state board, then it will be responsible for activities within their states only. It may also, these boards may spread awareness to stop air pollution, lay down standards of ambient air quality. They may collect, compile, and publish technical and statistical data relating to air pollution. It may also give out measures by ways of which effective prevention, control, and abatement of air pollution may take place. It may establish or recognize laboratories for analysis of air samples wherever air pollution are said to be in high ambient levels. So, the level of air pollution is measured by these boards and laboratories from time to time. As of today, the Central Pollution Control Board gives out information in an online manner or with the help of media as to tell the people what is the ambient air quality on a particular day in a particular place. So, the improvements which the technologies have made have also been accepted by these boards, and it is a process of providing information to the public or the citizens to take informed decisions when it relates to putting out information of air quality. The functions of the state board: the state boards under Section 17 of the Act have and can plan a comprehensive program for the prevention, control or abatement of air pollution and secure their execution thereof. They may advise the aid and advise the state government on any matter concerning the prevention, control and abatement of air pollution. They may collect and disseminate information relating to air pollution. They also work in collaborating with the central boards. The state board does not only have members or collaborate at the local levels, but it also collaborates with the central boards in organizing training of persons who are engaged or may be engaged in programs related to prevention, control or abatement of air pollution, and to organize mass education programs relating thereto. They may inspect the air pollution control areas at such intervals as it may think necessary, assess the quality of air therein, and take those necessary steps which are necessary for the prevention, control and abatement of air pollution in such areas. They also have the powers to give directions. Under section 18(1), it provides the functions which may be performed, that is, the central board is bound by the directions which are given to them in writing by the central government and which it may do so from time to time. Every state board is also bound in a similar manner in writing as the central board or the state government may give them directions to do so. The proviso of this section states that where there is a direction given by the state government is inconsistent with the direction of the central board, the matter shall be referred to the central government for its final decision. So, where these boards are concerned, they are in turn governed by the governments which are running them. They are in turn given directions as to how they need to function in a particular situation in particular ways. Under section 18, subclause 2 provides that where the central government believes that any state board has defaulted in complying with the directions which it has given out under subsection 1, and as a result of such default a grave emergency has arisen and it is necessary or expedient to do so in the public interest, it may order or direct the central board to perform any of the functions of the state board in relation to such areas. For such periods and for the purpose, it may all be, these directions may all be specified in the order which has been given out by the central government. The procedure when pollution takes place is again similar to that of the Water Act, except that the functionaries here may be different, the boards here may be different who are giving out directions. In India, wherever air pollution takes place, it is the central government which may ask the Central Pollution Control Board to take action, and where the board sends one of its persons to examine the place, he goes to that place by informing the industrialist or the occupier that he has come to investigate. He needs to collect samples within the vicinity or the establishment in the presence of the occupier, divide that sample into parts, give one sample to the owner and take the sample to the appropriate board, which in turn will send it to the appropriate government laboratory to be examined for the concentration of pollution within that sample. The laboratory analyzes those samples, prepares reports twofold, and they send one of the reports to the occupier or the person who is in charge of the establishment, and keeps the other sample or the report for the purpose of evidence to be produced within the court, showing how an establishment has created pollution along with its evidence. It is after he is after he has been asked to answer why a particular activity needs to be modified or it does not need to be carried out, and in case the person does not comply with the orders of the board, an order of permanent injunction may be passed against him to either change the activity in a way which is environment friendly, or to install treatment plants, or withdrawal of license from such a person in case he continues to create pollution by way of his establishment, unit or industry. The procedure for collection of samples of air pollutants is mentioned under section 26 of the Act, and it is similar to that of the Water Act of 1974. A state board or officer who is empowered shall have the power to take for the purpose of analysis samples of air or emissions from any chimney, flue or duct or any other outlet. The result of analysis of such samples of emission shall not be admissible in evidence in any legal proceeding unless the procedure contained in subsection 3 and 4 of section 26 is followed. Section 3 requires that when a sample of emission is taken for analysis, the person taking the sample shall serve the notice to the occupier or his agent of his intention to have the sample analyzed. I have already stated all this previously in the procedure of picking up samples and the procedure afterwards, that is taking decisions with respect to an activity which is found to be polluting, and then giving out further directions whether it should be allowed to continue to work, to stop momentarily, interim orders to be passed, or to place a permanent injunction on an industry and order the closure of that industry by showing evidence how their activity is not environmentally benign. The sample of emission which is collected in the presence of the occupier and placed in a container is marked, sealed and signed by both the person taking the sample and the occupier or his agent. Thereafter, the sample is sent for analysis to the laboratory under section 17 of the Act. If the occupier or his agent makes a request, the sample of emission may be sent for analysis to the laboratory established by the central government or the state government under section 28 subclause 1 of the Act. Despite the service of notice, if the occupier or the agent willfully absents himself, or the occupier or his agent is present at the time of taking the sample of emission but refuses to sign the marked and sealed container, the person taking the sample shall put his signature on the container and send the sample for analysis to the laboratory established by the government under section 28 subclause 1. At that event, a person taking the sample shall inform the government analyst appointed under section 29 subclause 1 about the willful absence of the occupier or his agent as the case may be and his refusal to sign the container. Now, the boards and the government have a power under section 19 to declare certain areas as restricted areas. They may identify certain areas for the purposes of analyzing air pollution. So, air pollution control areas may be marked, shown under the plans of establishment that these areas are restricted and may not allow certain levels of pollution to be created within or within the vicinity of such areas. Under the Air Act, air pollution is sought to be combated by means of declaration of restricted areas, prohibition of the use of polluted fuels and substances, as well as regulating the appliances that give rise to air pollution may be undertaken by the governments. Two important cases under the declaration of restricted areas are MC Mehta versus Union of India or the oleum gas leak case, one in Bhopal and one in Delhi, where certain areas were declared by the central government as pollution control areas in exercise of its powers conferred under section 19, and in Delhi in the plant of Shriram Fertilizers was in this control area where the gas had leaked. So, the government took appropriate action by asking them not to immediately start, but firstly locate the problem wherever it laid down, asking continuous monitoring to take place, declaring or making declarations both in both the languages which can be understood by the people, asking the unit to function in a manner where the opening and the closing are restricted and it only allowed access to very few people, since it was a very heavily populated areas around that unit, as it was an industrial area. Further leakage would have caused further death and disaster. The first leakage went on to affect a lawyer in Tees Hazari and other people who complained of certain illnesses when the gas leaked in the Delhi Shriram fertilizer unit. The other case where areas were declared were the alloy steel rolling mills versus West Bengal Pollution Control Board. The Calcutta High Court made it clear that court will not interfere in the direction issued under section 19, and they are to base their reports on expert committee and recommendations of the central board. Now, the offences and penalties under the Act. There are grave offences for which penalties which may have been prescribed at that time. Now, the problem here again comes out in a similar way, that when the Act was drafted and when it was implemented in certain areas, the penalty seemed appropriate and the punishment seemed right, because there were not many industries and there were not many incidents of industrial pollution or other pollution creating acts. But later on, as our societies progressed, later on as progress was made in the cities, more and more cities grew, more and more industrialization took place, the problem has become grave, and the penalties and the punishments still continue from the day it was drafted to be almost the same. It needs to be enhanced both as a punishment and as a compensation which is to be given out by the industrialist, for it does not work as a deterrent effect on the industrialist to continue carrying on that activity without hindrance and then paying a small amount of money or asking one of the persons who are officers or in charge to be punished for a mere time of 3 months, although it is stated that it shall extend to more years, but usually the cases are that they get away by paying a small fee or penalty in such cases. The punishments provided under the Act differ in accordance with the gravity of the offence. The acts of non-compliance with the directions issued by the board concerning the grant or refusal or consent by the board under section 21, or prohibition of emission of any air pollutant in air pollution control area under section 22, or directions issued by the board under section 31 of the Act are treated as grave offences punishable with stringent punishment. The offences and penalties. Section 37 of the Act provides severe penalties for failure to comply with the provisions of section 21 or section 22 or directions issued under section 31A. It provides that a person shall be punishable with imprisonment for a term which shall not be less than a year and 6 months, but which may extend to 6 years and fine, and in case the failure continues, with an additional fine which may extend to 5,000 rupees per day. A fairly nominal amount in relation to the pollution if air pollution is created. Nature of punishment is evident from the fact that minimum punishment for commission of such offences is 1 year and 6 months and the maximum punishment is 6 years. Punishment in the form of imprisonment can also be coupled with a fine. It is very inadequate in comparison to the natural resource of air which is destroyed by injecting air pollutants within such air, for the after effects are really disastrous and the activity does not earn some such economic income as to cost the life of others. It may further add to the stringency of the punishment an additional fine of 5,000 rupees per day's failure, which shall be imposed on the polluter in case the failure continues. Section 37 subclause 2 provides If the failure continues beyond the period of 1 year after the date of conviction, offender shall be punishable with an imprisonment for a term which shall not be less than 2 years, but may extend to 7 years along with the fine. As I stated previously, no amount of punishment and no amount of penalty can compensate what a polluted air has done to a living being, as well as a renewable or a non-renewable resource, or has created death and disaster where people cannot be brought back even if compensation comes in. And in accordance to the harm which has been caused, the compensation amount and the punishment factor is very low and very little, where they also invoke cases of strict liability, stating that they are not responsible because they did not know of the pollution or are not responsible for the actual incident. But the trustworthy case of our courts are that they have taken absolute liability principle, stating that we beg to differ from the English law that if pollution is created due to an external activity or a non-natural activity, then the person who is responsible shall definitely have to pay compensation, not only for the wrong done, not only to the people, but also to bring the environment as far as it is possible back to its original form. Other offences are Section 38 of the Act deals with penalties for other offences and provides, whosoever destroys, pulls down, removes, injures or defaces any pillar, post or stake fixed in the ground, or any notice or other matter put up, inscribed or placed by or under the authority of the board, or obstructs any persons acting under the orders or directions of the board from exercising their powers and performing their functions, or damages any works or property belonging to the board, or fails to furnish to the board or any officer or an other employee of the board any information which is so required by the board he has in his possession, or to such officer or other employee for the purpose of this act, or fails to intimate the occurrence of emissions of air pollutants into the atmosphere over the standards which have been laid down by the state board, or the apprehension of such occurrence to the state board and other prescribed authorities or agencies as required under subsection 1 of section 23, or in giving out any information which is required to be given by him under this act, but makes a statement which is false in any material particulars, not because he does not remember, but in a deliberate way, or obtains a consent under section 21, makes a statement which is false in any material particular, he is said to be punished with an imprisonment which may extend to 3 months, or with a fine which may extend to 10,000 rupees, or with both. As a result, if we look at the offences which have been laid down are very grave, but if we look in contrast to the punishment which has been prescribed under the Act is very little in comparison to what the offence or to what extent the harm might have been created. We see that if he pulls down, he destroys, he removes, he injures, or in other words, he destroys property and does not inform about the creation of air pollution or emissions which have been let out in the air, which are hazardous, which may be poisonous, or which are otherwise likely to cause an adverse effect on living beings or to non-living beings, there he is only given a small punishment and a meagre fine to be paid by him in case he commits that offence. The effect of the other laws on the Air Pollution Act. Section 52 of the Act states, the Air Prevention and Control of Air Pollution Act 1981 shall have precedence over other laws, and therefore the provisions of the Act shall have effect despite the inconsistency with the provisions of any other enactment. However, the provisions of the Air Prevention and Control of Pollution Act are subject to the provisions of the Atomic Energy Act 1962, in relation to radioactive pollution which occupies a predominant position. Thus, in cases of pollution caused by radioactivity, the provisions of the Atomic Energy Act 1962 becomes effective, notwithstanding their inconsistency with the provisions of the Air Prevention and Control of Pollution Act. So, each law works as a balancing act for the other. That is, if air pollution or emissions are created, there is air law to deal with the problem. But if in relation to an air problem, radioactivity takes place, which means a grave problem has been created, then the separate law takes over in those cases to provide effective, speedy remedial measures and to prevent it from spreading wherever it can be achieved. It was observed by the Supreme Court in MC Mehta versus Union of India that the orders of the Supreme Court can neither be nullified nor modified or in any way altered by any administrative decision of the central or the state government on grounds of having legislation to that effect. Amendment to the Air Act. The Air Act was amended in 1987 and some of the major amendments relate to the empowerment of the central and the state pollution control boards to meet with grave emergencies of air pollution. Why it was amended in 1987? Because it was in 1984 that our country and the world witnessed the horrible Bhopal disaster, whereby the gas which had leaked from the chemical plant within hours went on to kill several people and wipe out human population along with having a detrimental effect on the environment within that area. The horrible photographs which came out of the victims of the Bhopal tragedy are so horrible that the victims and their families would have immediately perished at that time. The compensation which came in was too little and too late for the purpose of compensating for a horrible disaster. So, the Air Act, when it was amended, it was a major amendment as it brought responsibility not only on the governments but also on the pollution control boards and they asked them to get trained people to deal with emergencies wherever such cases of pollution take place. The boards were authorized to take immediate measures to meet such emergencies and recover from the persons concerned the expenses incurred in the process. The power to cancel consent for non-fulfillment of the conditions prescribed is also emphasized under the Air Amendment Act. After the 1987 amendment, Section 31A was added, which gives the power to issue directions to that effect that such power includes closure, prohibition or regulation of any industry and the power to stop or regulate the supply of electricity, water or any other service. The major judgments which came out were that of as I have mentioned this case previously also, the case of MC Mehta versus Union of India in 1986, a writ petition was filed under Article 32. Prior to this, the Delhi oleum gas leak case and the Bhopal disaster had already taken place. They recognized the pollution which was created in the city of Agra and where the increasing pollution had started having its effect on the Taj Mahal, causing deterioration of the marble. The marble of the monument was turning yellow and brown due to the excessive amount of pollution within the area of the Taj trapezium. The Supreme Court noticed that degradation of the Taj Mahal was influenced by socio-economic factors as well as chemical pollutants. The court ordered 292 industries to switch to safer fuels like propane instead of coke and coal or face relocation. They also held in this case the Mathura refinery, which was producing smoke, and it was this smoke along with these industries which was responsible for air pollution within that area. The Gas Authority of India Limited was asked to oversee the transition of other fuels to CNG gas, and the court recognized the fundamental rights of the workers in these industries and ordered compensation for the lost wages during relocation. The other important judgments are of Mr. M.C. Mehta versus Union of India, or the CNG vehicles case. The Supreme Court's involvement in Delhi's air pollution problem originated over concerns that polluted air is poisoning its citizens. A widely cited study conducted in Delhi estimated that 10,000 people die every day due to complications from air pollution, a staggering total of 1 person every hour. In this case, the court mentioned that precautionary principle is enshrined in the concept of sustainable development. So, the principle requires the government and the health authorities to take appropriate action and prevent air pollution. According to this principle, if there is a threat of serious or irreversible damages, then a lack of full scientific certainty should not be used as a measure of postponing cost-effective measures to prevent environmental degradation. The other judgment are judgment of the Supreme Court in matters of Arjun Gopal and others versus Union of India and others in 2018 regarding the alarming degradation of the air quality leading to severe air pollution in the city of Delhi. The petition accepts that there are many reasons that have contributed to the poor air quality in Delhi and the NCR. At the same time, it emphasized that air pollution hits its nadir during Diwali time because of the indiscriminate use of firecrackers, the chemical composition whereof increases harmful particulate matters such as PM 2.5 or PM 10 at alarming levels, thereby bringing the situation of emergency. The Supreme Court directs that crackers with reduced emissions and green crackers should only be permitted to be manufactured and sold. Other crackers are usually banned during Diwali season. The judgments which were prior to today's world were again landmark judgments which went on to change the course of environmental cases and the law and the people, and also brought in, as society progressed, it brought in new problems and new problems to be curbed, since the law was already in place, but it was the implementation of the law which requires a stricter compliance. So, it was by way of the courts which showed, and their judicial activism which went on to pave the way and lead to show that certain substances should be banned, since they are responsible for not only the pollution but also the affecting the health and dignity of the citizens who might be affected by those activities. This was already witnessed in the case of Bhopal disaster, the oleum gas leak case, the Taj trapezium case. Then came the famous case of Murli S. Deora versus Union of India, where the state government of Rajasthan had given out guidelines that smoking should be banned in public places, since the persons who are smoking, they are not only affecting their own life, but they are also affecting the life of people who are sitting with them or within their vicinity or company. Since they become the active smokers, and the persons who are who have to survive or who have to be associated with them are passive smokers, since they also are inhaling the poisonous smoke emanating from those cigarettes. This case was taken up as a good example and also placed in Delhi, where smoking was a common activity amongst the office goers and people who are working in Delhi as employees. The next case, which had effectively brought its focus on the vehicles and the fuels which is being used for complying or these vehicles on the road, was the public transport system which was using diesel as its main fuel. In MC Mehta versus Union of India, or the CNG vehicle case, The court found that the vehicles which are plying on the road are mainly responsible for the air pollution which is being created in the Delhi and the NCR regions. So it asked for opinions as to what kind of fuel should be used so that the smoke which comes from the diesel and the working of these public transport systems helps in reducing the smoke or the black soot which comes out to a large scale. It later on also went down to for the closure of industries within the Delhi region and the NCR region. So it is these cases, the CNG vehicle case asked for CNG as an alternate fuel to be provided for the public transport system. The non-availability was cited and the government found out that it was companies like Maruti where the CNG fuel was redirected for an effective and a healthy running of that industry, which was being utilized by only a single entity. So it redirected the CNG fuel from other places to be directed to and to be used for plying government vehicles on roads in Delhi, and banned other private diesel buses from running absolutely. As the cost of running those buses, they made it so high that they had to pay penalty. They had to pay an amount of 20,000 rupees for a month, and after that they had to pay a certain amount of rupees per day, that the running of these such kind of buses was made very expensive. So as a result, by the orders of the court, they found that environmental law could be effectively put in place. The next case which I have previously talked about is Forum Prevention of Environment and Sound Pollution versus Union of India, where the use of the public address systems in night led to a crime being committed during night in that area where the public sound system was being used. This led to framing of certain noise rules and regulations under the law, where they stated that after 10 o'clock to 6 in the morning, no noise levels should be raised or allowed to be created, and during the festival days of Diwali and Dussehra, a special permission needs to come from the main authority or the office of the CM or the PM, as the case may be, for running of those pandals for festivities, but only up till the time of 12 o'clock. Beyond that, they should not be allowed to run, and only for a period of 15 days when the festivities continue during those festivals. So this law went on also to bring laws with relation to firecrackers, in relation to the sound system of horns and other sounds which might be produced because of various activities, declaration of certain areas as restricted or prohibited areas for creation of sound or noise pollution. So these judgments are important landmark judgments which went on to influence the life of the people, how far they were made effective, and they are also followed in the subsequent cases, where these cases serve as precedent to those cases, and as a result the law is enforced by way of the courts. Unfortunately, it is the will to file a case or bring the case to the public authorities is where again the lacuna lies. That is, if a person does not file a case or does not bring an activity before the court, then the remedy to that harming activity cannot be brought in. In residential areas, the public address systems can no longer be used after 10 o'clock. It is banned up till 6 o'clock, and we as citizens need to create this awareness to those who want to continue with the public address system after 10 o'clock in the night. A similar case of the Church of God in India versus KKR Majestic Colony Welfare Association, where the use of beating of drums was considered, and that too in the early hours of morning, were considered to be polluting, as students who were studying for the exams, and people who are old or have heart problems may be affected by use of a public interest address system and the use of beating drums as a part of their religious activity. So it was asked to be banned and to be made effective in a more efficient manner, where air pollution or noise pollution cannot be created. I've already given the example of an environmentally benign activity. One is that of during Durga Visarjan, people, or during Ganpati Visarjan, people use idols prepared by chocolate and then drown that idol by pouring milk on that idol, where the water is then distributed amongst people as prasad. So it is one of the very interesting ways where religion also can be practiced and environment also can be protected. In a similar way, if public address system needs to be used, it is now they need to take permission from certain authorities, and these systems are only can be used in enclosed places with the prior permission and not again after 10 o'clock. If certain conferences or important meetings takes place in these enclosed establishments, then special permission needs to be taken by these authorities to run certain programs. This is now I would like to wind up by giving an overall overview of the law. This law can be stated as the second law in relation to environmental matters. It was the only law which was available in the country when a disaster like the Bhopal disaster took place. They did not have any central law in place to deal with such disasters by way of government authorities or measures. So this law, when it was drafted, it was mainly to declare air pollution in case it was created in any region or area. The amendments later brought in changes under the law, and it was drafted and it was converted into a central law under the union list to be governed and guided by the central government. The boards were created under this act, which were to be performing functions in relation to preventing pollution and control or abatement of pollution. It is these boards along with the joint boards which carry out the functions of not only the board but also preventing activities which may not be environmentally benign or which may be causing pollution or emissions into the atmosphere. The board has the power to carry on perform certain functions and to carry on functions, including the power for the closure of an industry in case it is continuously creating problems and pollution and is refusing to stop that pollution, thereby affecting or giving harm to a large number of people. Under the miscellaneous programs of the Act, it further goes on to say that the central government is empowered to make rules in respect to the whole of the country, and the state government is also empowered to make rules with respect to the whole of the country. Acts which are done in good faith to prevent greater problems may be protected under the law wherever they are invoked for or wherever a smaller harm comes in order to prevent a bigger harm. These laws provide that they may provide information, they may provide programs, they may conduct all activities for the protection of environment which as government agencies are the Central Pollution Control Board and the State Pollution Control Boards. The central government and the state governments may frame laws, and the law is already in place. They may formulate policies for the protection of environment, and further it may also carry out the functions, and it may also see that the law is being enforced in a regulated and effective manner. For other cases where rights are violated because of a healthy environment, the courts are in place to get remedial actions, and in most of the cases where actual violations have taken place, the courts have provided remedies by asking the industry to not continue doing the same, or to install treatment plants, or to take appropriate measures wherever they are required to do so. So, thank you.
Hello everybody. Now the discussion which I would try to make talk to you is about the excitement which I always feel, and I am sure you will also reciprocate as I proceed and when you do the course, is in the area of multivariate statistical problems and multivariate statistical analysis. So, what we mean by multivariate? So, we know that statistics is a subject where you have a lot of data, you try to analyze that using different type of techniques like estimation problem, MCMC techniques, then forecasting and the area of time series analysis, and then try to basically find out the best forecasting tool which you have, such that you are able to gain the maximum amount of information from a set of data. Now, in the recent past, as we see that multivariate statistics has really increased in a very exciting manner, and if I trace back to history, it has been going on slowly for the last about 70-80 years, but now the time has come where it is being used in a very big way, and the techniques which we all know, but which are being utilized with new vigor are in the area of, say for example, canonical correlation technique, in the area of factor analysis, in the area of conjoint analysis, in the area of clustering analysis, in the area of multi-dimensional scaling techniques, structural equation modeling, be it in the area of finance, be it in the area of engineering, be it in the area of social sciences, be it in the area of economics, such that you are able to gather the information from the data in such a way that it really gives you some useful set of information. Now, in the recent past, there has been also an explosion of large and complex data sets, but added to that there has also been a commensurate increase in the computing and the statistical techniques. So, obviously, the question comes that if the statistical techniques are there for so called small data, not the big data, not the data which is of terabytes and so on and so forth, where you use different type of computers to store the data, the question obviously comes that are those statistical techniques really relevant when we use them in the big data sense. The question is, they are not always relevant, they may not give you the best results. So, what we are seeing in years to come, and I feel very excited about that, is that how the new tools which we have already learned in statistics, in multivariate statistical analysis, are being redrawn, are being, say for example, remodeled in such a way that they can be utilized along with the techniques of computing in a very nice manner, that we are able to garner the information from big data very successfully and very nicely in such a way that they are able to portray a sense of information which we all long to have from big data, be it in, say for example, medical sciences, be in the area of finance, be it in weather forecasting, be it in transportation, so on and so forth. So, obviously, it means that students, participants who are in a position with some brief mathematical background to take multivariate statistics and statistical tools as a subject in this program are assured of a very exciting future, where they can use these tools to both gain the knowledge as well utilize them in a very best practical sense, such that they are able to do some justice to the information which is given to them and get the best information from the data sets. I wish all the participants in this course the best of luck, and I am sure they will also reciprocate the excitement which I have for this type of courses. Thank you.